Good morning. I'd like to welcome everyone to our committee meeting this morning. We'll start the proceedings this morning in just a second by introducing our members. But before we do that, I'd like to remind everybody either to have their phone on silent or turned off. Also, I have a note here from the request of legislative television that asks people not to adjust their microphones. According to the television staff, these microphones cost about $1,000 each. And when they're moved around a lot, it causes wear and tear on them. They have to replace them quicker. With that, good morning. I would like to start by asking Mr. Ramey and go around the table and introduce everyone. Mr. Ramey.
Thank you, Mr. Chair. Gary Ramey, MLA Lunenburg West. Good morning, everybody.
Good morning, Matt Wynot, MLA Hammonds Plains, Upper Sackville.
Brian Scabar, MLA Cumberland North.
Good morning and welcome, Clary McKinnon, MLA Pictou East.
Good morning and welcome, Howard Epstein, MLA for Halifax, Shabukto.
Andrew Younger, Dartmouth East.
Good morning, Alan McMaster, MLA for Inverness.
Good morning, Chuck Porter, MLA, Hants West.
Anne McDonald, Assistant Auditor General.
Jacques Lapointe, Auditor General.
Darlene Henry, Committee Clerk.
Bev Whitaker, Director of Finance, Administration and Systems for the Public Trustee Office.
Emma Stelterio, Public Trustee of Nova Scotia.
Anne Early, the Coordinator for the Healthcare Decisions Division of the Public Trustee's Office.
I'd like to welcome our guests this morning, and Ms. Terrio, I would like you to make a presentation if you have one prepared. Thank you.
Good morning, Mr. Chairman, members. Many of you may not know much about the Public Trustee's Office, and I want to give you a little capsule. Nova Scotia's Office of Public Trustee is committed to properly administering the estates of children and people who are deceased, incompetent, or missing. We also provide informed consent for healthcare decisions, including decisions of placement in nursing homes and home care services. We make these decisions using an approach that is client-centered, respectful of human rights and freedoms, and is in the client's best interest if the person's prior wishes, values, and beliefs are not known. We're independent of government. It is set up as a corporation to protect the financial and personal well-being of its clients. Its authority to act come under 14 pieces of provincial legislation, most notably the Public Trustee Act, the Adult Protection Act, the Hospitals Act, the Incompetent Persons Act, and the Guardianship Act. We have 25 full-time employees, all situated in Halifax, including lawyers, trust officers, healthcare professionals, and accounting personnel. We also rely upon the experts, outside experts, such as real estate appraisers, auctioneers, and stockbrokers. We provide services in 4 main areas. First, we manage the estates of living people who need a trustee or guardian because they are no longer mentally competent and can no longer manage their financial affairs. We protect the client's financial interests by doing what the adult would normally do, looking after their own affairs, such as applying for pension benefits, completing tax returns, paying bills. This is one of our largest areas of growth. Fiscal year last year, we had 387 files, and we have already reached 445 files. So you can see how the area is growing. Secondly, the public trustee is authorized to administer estates of people who die with or without a will. There are various circumstances under which the public trustee takes these types of files, and we opened approximately 60 such files last year. We have 156 deceased estates under our management, and it's been said we have the largest probate practice almost in the province. The public trustee is the decision maker of last resort for incapable people, mentally incapable people. We provide informed healthcare decisions and nursing home placement decisions. In the past fiscal year, we made 1,261 healthcare decisions. Additionally, the public trustee is regarded as a resource information center for estate and trust law. We opened 352 inquiry files last year, and we provide our expertise and knowledge to lawyers, social workers, healthcare workers, general public, and even on occasion to a judge. We find by helping people in this way, we are saving government money because in many instances, some answers for their problems can be found by them taking on the files themselves, but it also serves us in recognizing quickly if there's a file that the public trustees should be taking on because there's an interest that we are mandated to protect. In the past fiscal year, we managed $47 million. The public trustee had a performance audit by the Auditor General, and one of the biggest compliments he could have paid us, he paid, in that he said we managed the money under care using a prudent investor approach, and that's high praise for a trustee. But with this praise came 16 recommendations how we can better deliver our services. We have agreed with all these recommendations, and we began implementing them right away. And I'm extremely pleased to inform you that 81% of the recommendations have been completed, in other words, 13 out of 16, and we have worked well underway on the remaining 3. Suggestions have come forward, recommendations have come forward, how we can better protect the assets of our clients when initially entering the properties, and we have started to implement new procedures in this regard, and we are still gathering information how we can best address this recommendation. We've already instituted formal performance review for all our employees, and we have implemented a large number of policies, as you can see, having already achieved 13 of the 16 recommendations. I've been in the Public Trustee's office for 33 years. I joined in 80, was appointed Public Trustee in 92, and I must say, I've always received a great sense of worth, and by doing the work we do, we make a difference in the lives of our clients, and I'm very proud to say that I am the Public Trustee, and I'm very proud with the people that I work with. And I welcome any questions you may have.
Thank you very much. Mr. Younger, you have 20 minutes.
Thank you, Mr. Chair, and thank you for your presentation. I want to start by understanding the role and the limitations of the Office of the Public Trustee. And I know there's a number of areas you deal with. First of all, I'd like to deal with deceased individuals and their estates. So obviously there's a number of ways. I understand the public trustee can be named as an executor, but also that a case can be referred to the public trustee. And I don't think there's any limitation on who can refer it to the public trustee. Is that correct?
There is no limitation. There are several provisions under which the public trustee may undertake a file. Under the Probate Act, there is a ladder of priorities: who's entitled to administer an estate if someone dies without a will. And of course, the first party entitled to administer the estate would be the spouse and children, if they are resident in the province. Then the next party entitled to administer the estate is the public trustee. After that, it is the heirs at law residing outside the province. Following that, it is a creditor. Following that, it is a trust company. And then there's a catch-all provision at the end that says any other suitable party that may administer the estate. We are also given provisions in the Public Trustee Act itself that gives us priority to administer an estate. For instance, the public trustee may have been acting as trustee or guardian of a person's estate, an incompetent person's estate, and they die. We may have had control of their assets for the last 5 or 6 years. Under the Public Trustee Act, Section 15, the public trustee has the right to administer the estate of that deceased person in priority to even the next of kin in the province. We also have priority to administer the estate if the following occurs. An individual may die with a will. The named executor is the wife. She is incompetent. The public trustee is already acting as her trustee. Normally, under estate law, the appointment of an executor is a private appointment specifically for that person. But because the legislature, I believe, realize that we're protecting the interests of that incompetent person. The legislation is drafted in such a way that if the public trustee reviews the matter, and we believe it's appropriate that we administer the estate to ensure that the money due this wife under her husband's will is going to be done properly and quickly, we have priority in that instance as well. Citizens may contact us as well. And we get files like this in many instances. Let's say a person dies, he is divorced, he has 2 infant children. The only heirs at law are the children. Not his mother, not his father, not his brothers and sisters, because we are also, without court order, guardian of the finances of every child in this province for whom no legal guardian in the estate has been appointed. The public trustee has the priority to administer that estate. So in many instances, when somebody dies and they have infant children, because we know that in all likelihood we will be managing the money for those children. If there's money to, we estimate, we get all kinds of information, what's in the estate, what are the debts, etc. We would exercise that priority. So there are many, many ways. You can see my enthusiasm. We wear many hats, and when we make the decision where we're going to take on the file, we try to decide what's in the best interest of the heirs. We also decide if there's money to work with. That is very difficult for us. The only money we have, and all the public trustees are largely the same, to manage a client's estate is the money of that client. So sometimes people will come to us and ask, will the public trustee take on this file? And all there is real property, and there's not a penny to pay the probate taxes or to pay the advertising, to pay the insurance, to pay anything. We wouldn't have that money to pay for it either. And that is the same, that is the regime across the country. So in those instances, if someone else will say they want us to administer, if in fact they, sometimes the families say, we don't want to do it, but we will actually, sometimes families will say, but we'll put $1,000 or $2,000 forward to cover these ongoing expenses. Sometimes we'll take on those files. But we always have to be careful that we're not taking on a file that would cause the province liability. Because if we consent to take on a file and we don't put insurance on it, we don't pay the property taxes, and it's lost a tax sale, that can be a liability for us. So I'm probably telling you more than you need, but... That's right. Sorry.
No, it's okay. I appreciate that. I mean, I think that's, you're right, your enthusiasm shows through. I think that's not a bad thing. What I want to, I guess what I want to focus in on on a specific area is there's obviously a relationship between the public trustee and the probate courts and the entire system. Now, some of these are, so somebody dies who hasn't been under the care of the public trustee, and there's an issue with the way that the will is being executed, and maybe it's with the executor, maybe the executor can't be found. I mean, there can be all sorts of things. So in the situation, and what I'm trying to figure out is whether there is a gap in the legislation or whether you already have this authority to deal with cases where the terms of the Probate Act are not being met. Do you have the ability to go in either on your own accord when you find out about something or at the request of a member of the public or...
No, we don't, and I don't think there is that in any jurisdiction. Anyone interested in an estate that someone has a concern if its administration is not proceeding properly or promptly, the interested parties, the ultimate beneficiaries, have the right to, there is a provision in the Probate Act that if an estate should close within 18 months of the grant. So the interested parties, as the beneficiaries, the heirs at law, do have the right to go to the court to seek an order that the registrar will order the personal representative, and that's what they call the executive administrator now, to come to the court to show cause why the estate's not progressing.
But they would have to know that they're a beneficiary first. And that's sort of the gap that I'm getting at is...
The public trustee's office does not oversee the management of every private administration of probate in this province. And I know the other public trustees do not as well.
Okay, and so does that, is it your sense that there's a gap? Because if you speak to the probate court, they say, well, it's not, they say the same thing, and they will say, well, it's up to the heirs to, of an estate to come and tell us that it hasn't been dealt with within the 18-month period. And maybe it shouldn't be under the public trustee. Maybe there's, but I still think there's a gap there somewhere that you have the probate court and the public trustee both saying, well, if it's not done in 18 months, then the heirs come, and that's right. But the heirs, of course, have to know that they are heirs in order to do that. And if the will isn't being appropriately probated, then they may actually not know that and be able to come forward. And so I'm wondering whether there's a mechanism, and maybe there's a mechanism through the Public Trustee Act or through the public trustee, I know you can't now, or whether there's a mechanism in another way to address those issues.
There is a public notice of any estate being opened. The Royal Gazette, an administrator or personal representative, they say, I'll call, must advertise the estate for 6 months in the Royal Gazette. That is the standard that we have and have had forever. So there is public notice to individuals that someone has died. So I would think if somebody dies and they are a brother or cousin and so forth, the alarm bells would normally go off and say, am I an heir? So I think there is a positive responsibility upon potential heirs to come forward. It is more difficult, I would think, that if it was a charity, such as the Heart and Stroke Foundation, if Mary decided to leave $1,000 to the charity, for them to know if the executor did not send them notice. But the Probate Act does, and I don't control the Probate Act, nor do I oversee the probate court, because when I go to court on any application, whether I'm guardian, whether I'm trustee, whether I'm a personal representative, because I wear all of those hats, I am bound by the same laws and responsibilities as any other trustee. There's no different standard for what we do when we undertake a file.
How is it, and I understand about the Royal Gazette, in all honesty, and maybe I'm the only person on this side that doesn't know, so I actually, without going and Googling it, probably wouldn't know exactly where to go look immediately for the Royal Gazette listings. And I know they do the same thing federally for legislation. They publish it in the Royal Gazette, and unless you know what you're looking for, you don't know to go there. So I understand that there is that public notice. Do public trustees in any other province that you're aware of deal with, and I recognize that it isn't your job to directly oversee everybody. I mean, you'd need an army of people to oversee everyone, but do any public trustees elsewhere in the country have a mechanism where the public can, where they act as, the public can come to the public trustee and say that there's a problem with the probate of this particular will, and it's one that, or this particular estate, and it's one that we would like you to look into?
No. To my knowledge, no, that does not exist. But if, we do get phone calls like that on a routine basis, and that's part of what we call our inquiry calls. We may have an individual that has questions about the administration of an estate, and we take our time and we go through the Probate Act and we reference the sections, and and so much of with the new Probate Act are in the regulations, and the government has seen fit to actually do a kit of how to probate files, and I routinely, a lot of people now like to circumnavigate the use of lawyers. I think lawyers are nice people, and I think we shouldn't all be circumnavigated. But we are in an age that people do think they can undertake many of these tasks themselves. So part of my role, and all the lawyers that take the calls, part of my role is to direct the people to the kits and I walk them through where to find them online. And so where the kit is, tell them where the probate court is. I give them the phone number of the probate court. And sometimes when you do that, you end up getting several other phone calls and so forth. And we have to, it's a very, we have to be very careful. And I always say, I am not your lawyer, because we don't want the liability of well, the government told me to do this. But you're very careful. We give them general information, general advice to help them, to guide them, to help them along the way. And I think that's how we're fulfilling our role in that regard.
Okay. One of the things, that sort of leads into one of the things that the Auditor General noted, and I'm just going through, you I assume it came from your office, gave us a current status update on some of the recommendations, which I appreciate. And one of the issues that the Auditor General had raised, which I think is related to this and applies to, I think it applies to some privately probated wills as well, is the accounting for what's in the estate.
Yes.
And the Auditor General had noted that there was the potential for issues in terms of adding up I guess the entire state, cataloging everything that was in a property, determining the values and ensuring that those values are fair to the heirs, and also for the 5% that the public trustee will get out of it. Can you tell me what's been done in that respect? Because I know that the Auditor General made a number of recommendations. To me, that seemed to be one of the most important, at least in terms of the heirs and so forth. And I think that problem applies to privately probated wills as well. So I'd be interested to know how you're addressing that.
We one of the recommendations we had from the Auditor General that we should do a risk assessment report. So we did retain and retained the Internal Audit Division of the Department of Finance to help us prepare a internal risk assessment report. That report, the final draft, was received by us in December, mid-December, maybe December 4th or something. We had to respond to their recommendations by the end of January of 2013, which we've done. They came forward with 11 recommendations, how they believe that we could strengthen how we are dealing with assets. And I'm pleased to inform you that all 11 of those recommendations have already been completed. At the same time, I commenced research with my counterparts across the country and obtained copies of all their procedures, how they're handling it. I've also requested all my case managers to do an analysis of the cases they undertook in the past 12-month period, that they could analyze how many files they took on had houses and or apartments, how many of those properties, after we did our research, were there assets that we could sell, and did we receive money from that? Basically doing a cost analysis and to determine of the files a sampling of the files that we manage, how many have resources themselves to pay for the cost of the securing and protecting of those assets. And that report's supposed to be in my hands. 3/4 of the analysis is done, and I've gave them a deadline at the end of April. I'm trying to develop a business case to see how many files can self-support this, how many files cannot pay. Then I must determine a solution, or achieve a solution. How do I address this recommendation? Would it be less expensive for government. I'm always bearing that in mind, how to work within our resources, how to best achieve our goals within the resources that our province has. And I'm trying to determine the best case. Should it be one province I've discovered actually has a private contract with the commissionaires, and they would be around the province, because we have clients everywhere in this jurisdiction, in the province. You can seek them to Niels Harbor, to Shelburne at any one time. To have someone who would be quickly responsive so they could be in a location. Some jurisdictions have them full-time on staff. So I'm gathering the information, try to get a sampling of what we have, of our sample case we have, and how the costing, the best business case to go forward, and I will be presenting that to government. I'm looking at all options and trying to do it in a studied fashion to find a good solution and a good Nova Scotia solution.
Thank you. I know I only have about 60 seconds left, so maybe what I'll do
Sorry.
is... No, it's okay. I'm never going to criticize someone for being enthusiastic about their job. That's very good. I will ask a question. You're not going to be able to answer it because the chair is going to cut you off, but I'll give you time to think about it before I come around to the next,
You get two
next round. Which is, I'm interested in whether you have found any limitations in the, you notice there are 14 pieces of legislation that govern your office, whether there are limitations within that legislation that prevent you from being able to do some of the things that you would like to do, or to even address some of the recommendations in the Auditor General's Act, or Auditor General's report, whether there are limitations in any of those acts or changes that you would like to see made to the legislation, which would allow you to better respond to the calls that you're receiving at your office and the cases that you're dealing with. You probably, there's 1 second there, so you won't be able to respond now, but you can think about that until
please.
I come back.
Unfortunately, your time's expired. Mr. Porter.
Thank you, Mr. Chair, and welcome to all three of you this morning. Good to have you with us. The question that Andrew just put, actually, I'll give you the time to answer if you like, because I was going to ask the same thing if there were some limitations that are binding you. It wasn't one of my first questions, but let's go there anyway and take a couple minutes if you'd like to sort of talk about
Ms. Terrio.
repeating that.
Thank you. The legislation, we have a fair amount of power already. And no, I am quite content with the authorities that we have. The authority, our legislation allows us to be trustee, guardian. One thing stemming from the probate question, if I may, we have utilized a new power that was just given to us, and I think it's a great power, and it's one that I suggested to be put in the Probate Act when I was part of the study implementation of the new Probate Act, is that the public trustee actually has the power now to step in and take control of assets of a deceased estate if we believe the estate is in jeopardy. And that's Section 18 of the Probate Act. So we have exercised it only a few times, but if we see there's great delay and we believe there are assets being could depreciate, and we know there are funds to pay for the protection, we learn that there are monies in the bank to pay the power bill, to pay the fuel bill, et cetera, to protect that asset. We can exercise Section 18. I write a letter signed and sealed with my corporate seal, and I can extract money from the bank and pay that fuel bill. And I have all powers of a personal representative. So that is great, and we are entitled to charge for our services, because I'm always cognizant of the fact that our program, like so many other programs in the province, we try to cover our costs as much as possible as good stewards. And if we do step in, we are entitled, when the executor or personal representative takes over, let's say they finally get their grant, they're back from Australia or wherever they are, We can account for what we have done, and we always account. And we're entitled to a fee for acting as that interim administrator, so we can help protect assets, and we can, at the same time, ensure that our services are compensated for that purpose.
Thank you. That was part of the question as well that I was looking at. Is there a flat fee in these services that you're charging? How does that work? Because it wasn't really outlined.
Every guardian and public trustee of Canada, when it's acting as a trustee or personal representative, does charge a fee. We charge the same, are entitled to charge the same fee as if we were acting as executor or administrator, as a private client would. Private, if you were named executor of your mother's estate, and it's up to 5% of the assets that we deal with. So we present our accounts when administered an estate, and the court determines. We just can't say we're taking 5% because we think we did a really good job. We present our accounts. We're always accounting the courts for all the services that we do, to the heirs, to the courts on probate, to executor after our living client has died, or to the child when they're 19. So we charge up to 5%, but that's determined by the court. When we act as trustee or guardian of a living file or a child's file, the civil procedure rules have determined what a trustee is entitled under the Trustee Act to fair and reasonable remuneration. The courts have suggested that a proper scale is 2/5 of 1% of capital, 0.004. So I usually work with a calculator when I tell families what that is. So if you had $100,000, I'm sure Mr. LaPlante could tell us, what is it?
400.
Thank you. We have mathematicians. 0.004 of the capital and 5% of the income. So many of our clients, particularly our living files, they have limited income. We may have a senior citizen making $12,000 or $14,000 a year. We're entitled to 5% of their pension income for our services. It doesn't cover what we are doing for those people, but we do receive that, and actually the Department of Health recognizes that we're entitled to this trustee fee. So that is what we do charge. In a probate file, if the file is $100,000, $200,000, largely we will get the 5% commission. But on occasion, when we have a very large file, $1 million, $2 million, $3 million, the probate court reviews the complexity of the work that's been undertaken, how difficult, and the court may award a commission of maybe 3.5%, 4%. To also let you know about our accounting, when we go to the probate court, there are set procedures how you must account to the heirs, and you must send your accounts to the courts 45 days before, and to all the heirs and beneficiaries within 30 days. So with those accounts, there's also a form that they say, I object to the account, I object to the commission sought, all those things. So the heirs have full opportunity to speak if they believe the commission is appropriate or not. So that is how we collect our fees.
Thank you. I want to back up a bit. That's where I had intended to start was, I think some people is a bit confusing. So can you explain to me from a physical aspect, what does this look like? You know, have you got a filing cabinet with several names in it that equate to the $43 million that you spoke of, or whatever, the 47, whatever the total is. How is this actually managed, like the physical side of this thing? And I'm a little bit curious about that.
I hope I understand your question, and if I go off on the wrong tangent, please stop me.
Sure.
We have, I'm a lawyer. You have to be a public trustee, you have to be 10 years a lawyer. I have 38 years and counting. And I have 3 other lawyers. I have 5 trust officers. So when a file comes in, depending what type of file it is, the living files are large, management of a living file, usually it's incompetent people. They're assigned to trust officers. We have set protocols and procedures what we immediately do when we have a file. We have performance standards now established when we normally, within 24 hours of our getting a file, we are sending letters to every pension authority, redirection of mail, freezing bank accounts, writing CRA to get copies of past tax returns to try to ascertain their last year's income. Because sometimes we have a questionnaire we send out to people, and we ask them to fill out as much as possible with the assets they know that party has, because it's very difficult for us because we don't know these people. You may have a client that's now in a nursing, in a hospital. They're hoping to place them in a nursing home, and the social worker will say, she has no attorney under enjoined power of attorney. She has no guardian. She's been always secretive with her money. The children have always said, Mom has told us nothing. So we try to get as much information as quickly as possible because we try to, I often call it cast our net and see what fish we bring in. So we immediately do all these things. If we know there's a bank, we have protocols set up with the financial institutions and with CRA that we even fax the letters to them and then hard copy the letter to try to immediately source where the income is so people will know who can protect that income. So then we assign that file, that file has been assigned to the trust officer, and they basically step into the shoes of that party. As far as placing insurance, we'll place our emergency insurance immediately on assets.
Can I stop you there? Just
certainly.
And I want to just back up a couple of seconds. You mentioned the example of the lady who, kept everything from her children. Are you saying in this case that the children are still available but have nothing to do with the file? And if that's the case, how do you get it?
Okay. The children may be, there may be children, there may be not. That doesn't.
Okay, I can understand the not piece, and it's someone who's,
yes,
there's no one left, there's no immediate heir. That's why I just wanted to make sure I was clear on something there.
Okay. And I can understand that. I know this so well that it's difficult. If there are children there, but the senior or the individual has not taken the advanced planning tool steps of having an enduring power of attorney, or the family have not made an application to the Supreme Court to be appointed guardian of the finances of their mother, though the children may be very, very well-meaning, and they would say, but we'd like to help our mother, they have no legal authority to go to the bank to say, tell me what my mother has, put it in my name. There are 3 pieces of legislation that empower the public trustee's office to become the immediate trustee of the financial affairs of an incompetent person. One's the Hospitals Act, the other is the Adult Protection Act, and now consequential amendments that came out of the Personal Directives Act, which changed provisions, added provisions in my Public Trustee Act. So we have, through legislation, the power to become immediate statutory trustee or guardian of those individuals.
As long as someone, sorry, I don't mean to interrupt you, but just for clarity, as long as another family member hasn't done that through the enduring power of attorney.
Correct,
okay.
correct. Or
right,
they
I just
don't.
wanted to be clear on that for the simplicity of it when you were talking about it. I'm thinking, well, what if someone else? But you've answered that. Thank you. I don't want to cut you off. Time flies by so quickly in our back and forth. Don't apologize. I as well appreciate your passion on it. And the physical piece I was talking about, if we can just move to that a little bit more maybe, was the, I understand the outlay of your office now gets assigned as the files come in appropriately and so on. I was thinking about the files and, the accounting, and when the Auditor General done his report, there seemed to be, if I understood it correctly, and maybe I was wrong, but there seemed to be some issue with how that was being done and tracked and accounted for, and I'm just kind of curious, maybe we can talk about the recommendations briefly. You said you've done 81% completed.
Yes, sir.
And of that, there's 16, there's 3 left then, roughly.
Yes.
Can you speak to the 3 that aren't done and maybe why? If you buzz through so many of them, you've done 13 of 16, what seems to be relatively quickly, if you will. What's the hold up on the other 3 if it went that well? And what are those three? Sorry.
Well, one of them, we've already talked about entering the properties and so forth. That sheer element, we are now working on to try to find a best business plan cost solution for the number one. But even in number one, we have strengthened some of our policies in number one already. I'm not saying it's not done because the final solution's not there yet. But some of the things to even strengthen what we're doing now, we have changed our caretaker agreements. We have the caretaker agreements being acknowledged upon the terms of their being hired. We've changed our inspector agreements, and we have a detailed listing of obligations and duties and functions that we want them to, and we're having them sign that they're accepting these obligations. We have put in a new procedure. There are occasions where assets, the client is no longer returning home. There is an asset, let's say a baby grand piano or a cuckoo clock that is left in the will of this individual to a daughter. The lady will never need the clock again. The beneficiary named in the will wishes to receive the clock when her mother dies. At the current time, the estate doesn't need the value of the cuckoo clock to help pay for her ongoing needs. So we will enter into a trust agreement with the beneficiary say, I really want that. We entered a trust agreement, so we've strengthened the trust agreements. We've now that they acknowledge they're holding it for the estate. And they're maintaining insurance. We have that all in protocol. So, in fact, though we haven't achieved completely number one, that was 6.1, we have done a lot of the framework behind it to strengthen it based on many of the suggestions that we've received from the Auditor General, which we appreciated.
Wouldn't it be easier, and I'm not a lawyer, and I know you've been at this a long time, and the department has been there since, what, the 50s maybe, or? Is that
73.
Correct? 73, there
73.
you go, thank you. So it's been there a long
40
time.
years this year.
40 years, and you've been there by the sounds of it maybe quite a while.
I look that old, too.
No, not at all. That's not what I was suggesting at all, dear. You just, and I'll use the cuckoo clock or the piano as two very good examples. They are a beneficiary, and I guess that does mean at death. That's creating a bit of a problem, though, isn't it, for the public trustee to some degree? If the person is no longer using that, and I'll just say if it were me and I was leaving that item to my family member, is there no way to make that go to the family member sooner, or is that not a recommended change? Or? And I only say that because it's costing you money, time and effort and so on, plus you have all the accounting procedures that go along with that. So I'm just curious if that's something that's ever been tackled by way of, we were talking about changes or strengthening things, and I'm wondering about that.
We're going back into historic equity and trust law.
Things I know nothing about, that's why I'm asking. I apologize.
Not at all. It's a question that's often asked.
Okay.
A guardian or a trustee, we are not authorized to give away the assets of an incompetent person. Now, if someone had done an enduring power of attorney document, and they specifically addressed that issue and authorized the attorney to give away assets, they could. But by law, and that's not just the public trustee, we're talking about any trustee, any attorney, any guardian, even appointed under the Incompetent Persons Act, you have no right to give away the assets of that incompetent person.
Until they're deceased.
Until they're deceased. A will speaks from death. Yeah. But what it also does is if there was a change in circumstances, that client, that person, you have to manage the estate for the benefit of that person. So at some point in time, if I needed the proceeds from the sale of that clock to benefit that incompetent person, it is there. So we try to render respect always to the wishes of our clients having been expressed in their will. And what we also do, because it could be an asset that was a great emotional value to that family member, if our client needed that the money from the cuckoo clock, we will get it appraised, and we will make the first offer to the person named in the will saying, your mom wanted you to have this. We need the money to maintain your mother or to pay her accumulated debts, because of course they don't go away. We try to honor saying, and of course, appraised value is auction value, which is not the cost of the cuckoo clock at the local furniture store. It's always a quarter to a third of the value. So that's the way we try to honor that bequest.
Okay. I've only got a couple of minutes left, that's fine. It's not as simple as money in, money out, and I guess when you think about something like that, I guess having been there and been the power of attorney for my mother and looked after a similar, she didn't have a whole lot, so like not to the detail that some would have, so she would maybe an average one, I don't know. But I'm just thinking back how complicated that was, and it's confusing for people, I think is probably fair to say. They don't know that's there. I think sometimes maybe they don't know where to go, and I don't know if they know what the opportunities are to, I don't want to say pass it over to the public trustee, but to maybe contact them to see if that's the right place to go or not, and maybe in some cases it is. I want to, again, with just a minute left, I'll ask this question to finish it off. When you compare what we do in Nova Scotia to other jurisdictions in the country, where are we by way of, and I'll speak to the, with regards to the Auditor General's report, you know, it was about the accounting procedures and the risk assessments and so on. Where do we fit prior to and now, if you can, and you may not have enough time to answer all that, but.
I think we are doing a very good job. In all the years I have been at the Public Trustee's office, how we have managed our files, we have never been sued, and there's no judgment ever filed against the Office of Public Trustee for mismanagement. So I would think if we were doing a poor job and not tracking and not accounting, that surely in our litigious society, we would have been sued by now.
Order, please. Unfortunately, Mr. Porter's time has expired. Mr. Epstein.
Mr. Chairman, thank you, and Ms. Terrio, welcome, and thank you for the presentation. This has been very interesting. As you know, I'm also a lawyer, and in the past, although it's been a long time ago, I was in general practice and did have from time to time occasion to have contact with the Public Trustee's office, and I think what you just observed a moment ago was a very telling point, that is the fact that the office has never been sued. I think I recall your predecessor, was Martin Bushell your predecessor? And
yes.
Am I right in thinking that there have just been the two
there are
public
three.
Trustees? Oh, there were three. Who were the three?
Mr. Epstein, when I having a brain freeze. It is the third gentleman, Clint Havey. Mr. Havey was the first public trustee.
Right. Yes, thank you.
And he started off the ground, and then Mr. Bushell was appointed in '79, and he retired in June of '91. And I'd been acting public trustee at that point for probably about 7 or 8 years, anytime Mr. Bushell's absence. And we started 7 staff. Right. And then I was appointed in January of '92 to be permanent public trustee, and I'm actually the longest serving public trustee in Canada.
I'd forgotten Mr. Havey, and I apologize for that. But the record is a distinguished one, and you're right to point to it. I have to say that I'm not aware of any complaints out there amongst the practicing bar about the public trustee. And as you pointed out in your notes, the audit here was a performance audit, not the annual financial audit that takes place in any event. The special look this time by the Auditor General had to do really with systems as much as anything else. But in terms of the money accounting, am I correct that this has always been passed by the Auditor General every year?
Yes, we have been audited every year by the Auditor General. We have found their input over the many years to be of great help to us, because they've always helped identify areas which could be stronger. And before the change of approach with the Auditor General and all auditors across the country after Enron, it was our practice before we did any moves, especially when computerization came in '94 for us. Every step that we took, I would always say to the accountants, please pass it by the auditors. Please ensure, I want them to be comfortable to say, yes, you're going to have protections. Now, they're no longer authorized to help us in that way, but we've always used the Auditor General, or in past we did, and our accounts, our numbers are always there. There's never been a finding that our numbers are that we're managing for our clients has not been there. There's been no defalcations, and at no time in all the, and I still manage a caseload and trying to cut back as the work, but I've always had my hand on file management. At no time in any of the thousands of files that we've presented to probate court, to children when they're 19, or to executors when our living clients die, there's never been anything wrong with our accounting. So we have a system that balances well, that we present account statements that are adequate, that shows every cent coming in and every cent being spent on behalf of any of our clients. It's all there.
Right.
It is.
Just as a precautionary matter, I wonder, should it ever come to a lawsuit at some point, one hopes not, does the public trustee maintain insurance, or are you self-insured?
The province of Nova Scotia is my insurance. It's in the legislation that if there's a judgment against the public trustee, it is a judgment against Her Majesty.
So when you described the office originally as independent of government, I think that would have to be modified in some ways, because as I understand
I'd never thought of that.
As I understand it, the Department of Justice actually is the source of funding for the office in terms of your office space and so on, if that's
yes.
not adequately generated by your own fees. Is that right?
Yeah, yes, it is. But the legislation states that I report to the Auditor General, Minister of Justice, I guess, for administrative purposes. So I can, and I have, taken positions against government. Particularly when
I think we understood the independence in a
yes,
different way.
So,
that is
yes.
There's two aspects to it. One,
yes.
one would
yes.
be the financial
yes.
interaction, which is there, and the other being the fact that it's an arm's length entity that,
exactly.
that has its own mandate by statute.
Exactly.
Fine. Okay, can I just ask about the Auditor General's recommendations? I think my colleague Mr. Porter was asking about these as well. By my count, actually, I think there might be 4 that are still outstanding. I have 6.1, 6.3, 6.7, and 6.16. Maybe we can go through them. In the document you seem to have given us about the current status of the different items. The 4, well, first let me just say that as I read your comments, you accept every one of
yes.
the Auditor General's recommendations. So all we're looking at is really the extent to which they've been implemented. Is that right?
Yes. Do you have a report dated April 16th?
I do, yes.
Okay.
Okay.
Okay. What's the number again, please?
6.1, 6.3.
6.1, 6.3, and 6.16 in my mind.
And 6.7.
6.7.
So
oh, that's performance standards?
yes, it is.
That has been completed.
That's now completed? All right. So
Oh, I'm sorry. That was missed. That is completed. So that has to be changed.
all right. So this document needs to be updated slightly. 6.7 is now completed. Is that right?
Yes, sir. Well, I'm sorry. We had put that in. We put the document in, and I missed when we were going to that point to say that the word completed should have been there, and I thank you for raising that.
Okay, well, thank you, because this seems to be an important one, which is that the office should establish and monitor performance standards to ensure staff are meeting performance expectations. So you're telling us this is now
Yes, and if
done.
you read the actions taken, it did say it was adopted and came into force on December the 11th. It was just my error in not putting the word completed.
That's okay. Then let's go back and look at the three, as you originally told us, still needed a little bit of work. So the first one, 6.1, is the one that has to do with the process of moving, I think, with some speed to make sure that the assets are properly accounted for and collected, and that there shouldn't be any unsupervised persons having access to the personal property of any client of the public trustee. And so was this where you were talking about the possibility of enlisting the commissionaires?
That is
or was
just
that somewhere else?
Or that is the issue I was discussing.
So can you just tell me how exactly an altered system might work here?
The only province I found this in was in New Brunswick. And they have money in their budget to cover the cost of hiring this independent party to go in to investigate with another party in attendance, usually an auctioneer. So there'd be two of them.
So the idea about the commissionaires, if one assumes that maybe at some point
if it goes that way,
if you did that, they would be the agents of the public trustee who would be there to accompany the auctioneer, for example,
yes.
Who goes in to assess.
And they'd be together at all times, enter the property together. But that is just one way of trying to achieve the solution. I've not found the exact solution yet. I'm still studying the numbers, trying to cost it out to make my business case to present to government to ensure that I get the right solution for number one.
Maybe I'm just going to jump ahead here because one of the reasons I was asking about this is it made me wonder about the extent to which there are national standards for offices of a public trustee. And I was struck by your comment earlier when you said that when you were grappling with this recommendation 6.1, you sent out messages to your colleagues across the country asking them to let you know what they do and putting this whole issue in front of them. Are there national meetings of public trustees? Do you get together on a regular basis?
We do.
How often? What happens? Can you tell me?
Once a year. We exchange information about computers, about my brain freeze again. Just so many topics. Right now we have a national committee on banks and the difficulties we're all experiencing about the promptness and response to get back to us. We were entering and lobbying with the Bankers Association of Canada. We work on, we exchange information about investments, not investments about by Bank of Nova Scotia, but just about investment protocols. We exchange information about when we were instituting the new health division. So we use it as an exchange of information, trends. We'll even talk about if other provinces are having performance audits.
Yes.
What are they finding in their performance?
I actually wondered about that. Have you shared the Auditor General's report on your office with your colleagues?
Oh, we certainly have. It's a public document, of course, as you'd know. But we work on seeing what they're finding. It's always an exchange of wealth of experience, and as we often say, it's not so much what is at the table. We used to meet every 2 years. Now we meet. We used to meet in 18 months. Now we're down. As of 2 years ago, we meet every year, and each province takes a chance hosting it. But it's the little things exchanged over coffee. Yeah. I have a problem in this. Have you had a certain... It's that type of... We're exchanging our experiences of trying to find solutions.
A very valuable thing. I agree. Can I just ask, do you happen to know if any of the other public trustees have been audited by their auditors general in their provinces? That is a performance audit. I mean a performance audit.
Well, Alberta just went through one. I know, I think Saskatchewan's gone through one. I can't tell you.
That's right.
Mr. Epstein, I'm sorry.
So at least 2 other provinces have had a performance
I'm sure
audit.
others, unfortunately,
It's okay. And do they also share these, or your attention perhaps has been drawn to the existence of these other audits? How
they don't raise all, when they've had experiences before, as you can see in our performance audit, there are some quick fixes, and of course, as much as I get done as quickly as I could, I did. And the report came out in May, and here we are in 11 months, we already have 81 of them done and work on the other 3, showing the significance, or we put the significance on this. But it's the big issues, and so if somebody says something about our auditor says this, I'll come back to my office and say, look, how are we doing this? Can we strengthen this? So we draw upon the experiences in the other provinces.
In your annual meetings with the other auditors general or the other public trustees, has there either been a time or will there be a time to formally consider as an agenda item the performance audit reports that came in from auditors general?
We've never put that on the agenda as such, but we have, whoever has had it, last year after our report, I went to the meeting in June, and I stressed or highlighted some of the recommendations. I shared it with them, told them some of the areas I'd really be drawing upon their help to help me find solutions. This general experience. Shared the experience of how you got ready or prepared for a performance audit. The experience how you prepare and get ready to give your responses. We try to use these meetings as an opportunity to learn, because we do unique work. And so the other jurisdictions, the other public provinces and territories that are doing the same type of function or trying to do the same, like all of our duties may vary. Our core duties are largely the same. So we use these meetings as an opportunity to train. Our association also has working committees throughout the year to study different subjects, to bring back reports, to help us do our job better.
Right. It's unique and also valuable work. One of the reasons that I asked about the annual meetings was I wondered if there were either national or international standards for public trustees. So, for example, I think about a profession like accountants. I mean, they're sort of national and international accounting standards that prevail within the profession, and often books that embody procedures and so on. Does such a thing happen to exist for public trustees or not?
No, I've never seen them in all my years of experience, but the books that are in existence and that we draw upon regularly are legal texts, court decisions, because as you make decisions about the management of a client's account, how you deal with their joint bank accounts, if there's a husband and wife, we're guided, and we've developed policies in relation, and we have a draft policy right now on joint bank accounts. It's not been signed off yet, but we're working and have been working almost a year on this policy. But we're taking experience from and knowledge from court decisions and how the courts are guiding, so that when we deal with these assets, that we're doing so according to law. Because I've often called my office is basically a trust company in the government sector. So we have the same responsibilities and legal responsibilities, trust responsibilities, accounting responsibilities as any guardian, any trustee, any trust company. So though there may not be textbooks of how you run a public trustee's office, there are dozens of textbooks on trusts and equity and all of that.
I agree completely, and the parallel is a very good parallel. Could we continue through the outstanding recommendations, the other two from the Auditor General's report? We had looked at 6.1. What about 6.3? This is the one where the office, according to the Auditor General, should review its policies on real and personal property to include a general direction to staff to consider and address risks to all property. I'm not sure I understood exactly what that meant. Could you explain that and tell us what's going on with that?
We have started work in that regard. I have developed a tool that is to be put in every client's file. As we select a caretaker, let's say, the elements we have to decide what kind of risk. Is there a conflict of interest? How can we alleviate that conflict of interest? And we were doing so many of these things already in our work. And when we were going through the performance audit, we explained to the auditors that met with all the staff and myself, this is what we're doing, but they're saying, but you don't have a paper trail. So now I've developed policies so the trust officer or the case manager, when they're selecting a caretaker to be installed, the things they should consider, the factors they should consider, and direct their mind specifically in writing, so that party can look and say, okay, this is an issue, or how do I deal with that? So and every client's file is now going to have that. So we have commenced identifying what are potential risks, how to ameliorate that risk or eliminate that risk. The auctioneering services, we have changed our letter with them. We are now seeking confirmation that they have sufficient liability insurance to cover the value of the assets under their care. I believe 6.3 will be fully completed when we have 6.1 completed, because when we finally find our answer to how we address 6.1.
Order, please. Unfortunately, Mr. Epstein's time has expired. Mr. Younger, you have 16 minutes.
Thank you very much, Mr. Chair. I wanted to first follow up on something we were discussing before, and I'll try and leave enough time to answer the question about the missing point in the legislation, so you have lots of time to think about that. We were talking about sort of where the potential of a gap, and I'll table this in a second, but Section 18.1 of the Public Trustees Act says, and you probably know this far better than I do, but where it is brought to the attention of the public trustee that a person has died and the person's personal representative or persons entitled to share in the distribution of the estate have not taken possession of the property of the deceased person, the public trustee may take possession of the property for the purpose of protecting and preserving it, and pending a grant, the public trustee has all the powers of a personal representative with respect to the property. Now, when I had read that, and I can table that if the chair wants, but that's basically the act. So when I had first read that before, of course, being a layperson, I didn't read that personal representative as executor. So based on your first discussion, we now, I think, all understand that that's the executor. So getting back to that issue of if there is an estate where the executor is not doing their job, that strikes my read of that is that your office actually can then take control and become the I'll use the word executor because I think that's the word that most people...
I like it better.
Yeah, there you go.
And actually, I raised that as an example that we have exercised that. That's before the grant, though.
Okay. So that would be if the executor hadn't even gone... So once the executor is approved by the court, then that section does not apply?
That does not apply, and then we are legally obligated, and are pleased to do so, of course. We account to the executor after they have their grant. We've only used that section a few times. Actually, I've used that section a few times to help families in very desperate need. We are contacted often by a family that, or friends, use example friends, that they know an individual has a bank account, the party has died, and they're trying to find money to bury the person. They don't know if the person has enough money even to bury the individual, or should they be contacting community services. So we are sometimes contacted by families who says, we know he has the bank account, I've gone down to the bank, and they won't tell me what is there. So I said, I'll use my powers, and I've actually written to the financial institution, and it's sometimes difficult because you don't have a funeral director's statement of death yet because they haven't signed the funeral contract yet, but we say he is dead. And we say, we're exercising his power to take control, and I have all powers, as long as the letter's signed and sealed by me, and I get them to tell me, is there enough money to pay the funeral bill? Because the last thing you really want is a good, willing neighbor, friend, or even a son who doesn't have the money to pay for his father's funeral themselves.
Getting stuck with the bill.
Getting stuck with the bill, because I tell them, don't sign the bill. If you can't afford the bill, don't sign it. That's the type of advice we give them. So I've actually utilized that power to find out if there's money, and if there's not, I advise them to contact community services. Or two, I'll say, there is $3,200. He worked full-time. He's going to get $2,500 CPP death benefit. And I've actually used my powers to pull in that bank account for them.
Okay.
And that because we know the funeral is one of the first charges against any estate, actually Canada Revenue Agency is, but due to public policy, the body must be buried in dignity and all of that. They don't kill you if you don't pay an outstanding income tax bill, even though they have priority. So I've actually gotten money out of the banks and paid it right to the funeral company, because I know I can get a lawful receipt and protect my office, and protect the government. So I've used it for that. I've used it for circumstances in which there might be difficulty obtaining, getting the executor in province to swear their documents. There's things that have to be cited very, very quickly, acted on very, very quickly. We're approached, and I've used that power for that. I used it in a limited fashion, because it'd be a huge draw on resources if we used it all the time.
Well, I agree. I think that, though, that probably is somewhere where maybe there is and whether it should be by your office is I guess, another debate. But there is a limitation there, because obviously once the executor is appointed in a particular estate, if they then don't do anything, if that section doesn't apply, there's sort of this black hole of, well, there's an and I'm not suggesting that that's your fault, because obviously the legislation doesn't provide for that, but I appreciate the clarity on that section, because I think that points to a gap, at least maybe not in your office, but in the probate system overall.
I don't believe that in any province that is something that any public trustee is doing.
And that might very well be the case, but I think whether it's the public trustee or maybe it's an additional authority on the probate court, I think it's a gap, and even if that gap exists in other provinces, it's probably a gap that should be solved. It's not. There probably aren't that many cases in the run of a year, and so I'm not suggesting it's a rampant problem. I really have no idea, but for the few cases that there are, I think that's important. I wanted to also ask about one of the things that was talked about in the Auditor General's report is sort of the securing of assets. Now, I want to understand, if somebody dies and it is a case that you're going to take over as the public trustee, there is a gap between you being assigned or taking over the case and things beginning in terms of whether there's an auction or an evaluation or somebody going in. And I suppose it could be a gap of a few hours, or it could be a gap of a few days or a few weeks before somebody can go. And it probably also depends on where the person's estate is in the province. Because you noted that sometimes it's a bit, in your responses to the Auditor General, it's sometimes more difficult if they're further away. How do you secure as soon as you become in control of the estate, how do you go about securing the property?
After we are in control,
Because I understand you can't secure it before you're in control, but...
and you mentioned we are sometimes contacted about files because the family's been fighting for a year and a half and a property has been vacant for a year and a half because no one can decide in the family who wants to take on the file. So there is a huge period of time that we would have no control over, that people are coming and going inside those properties. But after we take over a file, we immediately try to secure keys, try to determine who has keys. If we believe that we have ideas that could be many keys, we will change locks. We immediately check into if there is insurance on the property, and if we cannot obtain the answer pretty darn quick, we immediately put it on the public trustee's master policy. That's one of the benefits we have gotten through our association with the volume buying. We can get vacancy insurance. Well, many people can't get insurance because insurance, let alone the premium, is high. They won't even insure it. So we will insure it. If we find out later there is a policy, we can cancel, but we'll insure immediately. We try to determine who has been caretaking the property, if anyone. We query the background of that party. Is it someone who the deceased trusted? We speak to the family members. Are they comfortable with having this person continue to act as caretaker? And we make a decision whether we'll allow that person to continue to act as our caretaker. There are instances that there are no family members, there are no living nearby or willing and able to do it, at which time we have sourced through checking references and so forth, individuals who can act as caretakers. We have an established policy, which is even tighter than is required by our insurance, requiring people to enter the properties on a regular basis, to keep a record of when they're entering the properties, doing the condition of the properties, and reporting back to us. We pay a very nominal fee for the caretaking services. The estate, of course, pays. All the activities that we do for any of our clients, it's the client's assets that are paying for the services. It is not the government. Because we do get those kind of questions. People ask, they just assume that if we take it over, we're going to foot the whole bill.
Well, that would be the same with a private executor as well. So that,
exactly, that we're acting as a private executor would.
So, but in terms of, how long does it usually take on average to secure a property between the time, and I do understand that there can be a long time before you get it, but you can't realistically.
I'd say within a couple of weeks.
A couple of weeks?
At the max. We try it as soon as we can, but initially we have to ascertain how to get into the property. But after that, we very quickly try to get someone in there.
Have you looked at whether there are opportunities to, whether there's a lag in the process that could be addressed in some way?
I've obtained standards from the other public trustee's office, and I'm finding that even some of them have much longer periods of time.
Okay. All right. I had, before I'd run out of time last time, and I know I have a few minutes this time, so I can go back and ask the question. Do you find that there are any limitations, especially in light of reviewing the Auditor General's recommendations? And I respect the fact that most, if not all of them, are either underway or completed, and I think that's very good. Are there areas in the legislation that govern your office or that you use that could use clarification or changes or strengthening that would assist you in better serving the purpose of being the public trustee?
Not really. Not really. We have strength in our legislation. I have the authority, and if I sign and seal a letter and tell someone to do something, just the legislation says as long as the letter is signed and sealed and I quote a certain section of the act, that I have the authority to do it. Okay. So I think the legislation that we have is quite strong. I was really impressed with the new Personal Directives Act, which was passed in 2008, I believe, which even gave more powers and protection to people and gave the public trustee more authority. I was always concerned about health care, and my office was being asked to give health care consent for surgeries, largely, because a person was incompetent. Now the government's taken the very big positive step that now the public trustee is now the substitute decision maker of last resort for every mentally incapable person. And so I'm now empowered. So that was a big step. So I'm now empowered that our unit, and Ms. Early that's with me, we can speak and review requests for health care and placement decisions for people that are mentally incapable. It also protected the family members who are making that decision but didn't really have the legal authority. And that legislation also gave us the authority to step in and become financial trustee of individuals largely who are being placed, whether with our consent or the consent of the substitute decision maker, and then they needed a guardian or a trustee to manage money. And it's given us even more power to step in and take over those finances of that person, secure their money, secure their assets. That's been a great benefit because in many instances, we're helping the backlog at the hospitals when they had nursing homes didn't want to accept someone unless there was a guardian appointed because they wanted to make sure the income was secure to pay towards their cost of care. So there's a lot of good legislation that we're working with, and very positive steps have been taken. And the biggest one recent was the Personal Directives Act. And I was often, I would say to a hospital when they were seeking health care consent for a surgery, how long has the client been with you? I'm sure you've not given them an aspirin in the last 6 months that they're waiting to be stabilized, and they would be a dead silence. But now, through this legislation, through the financing of that division in my office, we now are reaching out to group homes and hospitals and nursing homes. They have no one when our clients aren't there. And we're making informed decisions for them, protecting them. It's all good.
Okay. Mr. Chair, I got 4 seconds, so I will turn it over to my colleague.
Thank you, Mr. Younger. Mr. Porter.
Thank you, Mr. Chair. I guess I want to get back to a bit of the accounting side, and you spoke about all the years that this has been in operation in place, never being sued, and that's all a wonderful thing. You know, that's great. That does speak volumes to how things are getting done and the people that work there and all of those things. When the Auditor General did his report, however, there were some things, and obviously you've agreed with a lot of it because you've already began and made multiple changes. Can you tell me a bit about how you account for everything? Is it just a general spreadsheet? How does this work?
I am.
Is it that easy?
I'm a fairly experienced lawyer, but I think I better direct that question to someone who knows much more than I in accounting, and it's Ms. Bev Whitaker, who's Director of Finance Administration and Systems in my office.
Thank you.
Ms. Whitaker.
Good morning. Currently, we run a system which is called a Public Trustee Account Management System. Better. We affectionately call it PAM, so at times I might refer to it as PAM.
Okay, sure.
This system besides accounting for, let's say, the client information, it also does account for the financial items of our clients. So, for example, when funds do come in through the front desk, receipts are created. The money which is coming in is reviewed by 2 people signed off to ensure that we have good, secure processes in place. As well as when it comes back to accounting, the funds get deposited into the client's account. We have different segregation of duties there with signatures. And at any point, we could see, for example, for client XYZ, we could pull up and actually see what has been going on in their account. The one great function of the PAM system is that we can run what's called a client information, a client statement, which basically details all activity which has occurred into a client's account. So all the funds coming in, all the funds going out. So any payments, for example, if we have a client that may have a house with a power bill, it will show the payment of the power bill. Also, any purchase of investments that we do on their behalf to ensure that any funds that we have are being maintained and being kept. And from there, we do produce financial statements for once a year. And those are the items that are given to the Auditor General to review during their financial audit. So for the actual information in the PAM system, it is all detailed there. It's a regular money going in, money going out. Probably what's, just to kind of refer back to 616, which is an item about the need for a comprehensive accounting system. Really what it is the extrapolation of the information from the public trustee accounting system into the presentation on the financial statements. It is a process which is a little bit timely. We actually may have to sum items up on Excel sheets, and then those items are put directly onto the financial statements. To help with this process, a mapping has already been completed, which shows how a number which shows up on the financial statements, where it originated from on the public trustee accounting system.
How long has the PAM system been in place?
If I can give you a little bit of history here. When I started with the Public Trustee Office in 2003, there were 2 systems, one being a DOS-based system and one being an Oracle-based system. The 2 didn't talk very well to each other. So in 2005, we started the procedure of looking for a new program which would give us more flexibility, provide some of the items that the Auditor General, I think even had been asking for at the time, such as accrued interest, being able to pull that information. So at that time in 2005, we went to the different public trustee offices. We also checked to see what other products were out there and available that would take care of trust accounting. We had discussions with IT, and basically we did an analysis at that time, and the decision was to go with the public trustee accounting system. It is an Oracle-based system, which is supported by our IT department. Throughout the years, as new information has been required, for example, can you run a report on this, or we'd like to be able to see these details. The flexibility with this program has been that we can go to our wonderful IT people and say, can you possibly give us this information on a report? Or can you modify this? Can I have this field added? And they have been wonderful, and they've been able to make those changes.
Okay. You spoke a minute or two ago there about, you file your year in and all of that. What's the process? I'm not sure, I don't want to put words in your mouth. You used it was a bit time consuming, I think, there. what's the actual process now? You got to get into this gap standard, I assume, that you're, the general accounting principles that are required or being recommended at least.
Yes. The process is that, actually, just to take it back a couple steps.
And maybe just on that, while you're going through it, you could, the next piece of that was risk for error. I was curious about the risk of error in all of this.
Sure.
Yeah.
When we balance our accounting work on a daily basis. From there, we also, at the end of the month, pull different reports from the system. These reports are then used towards the preparation of the financial statements at the end of the year. On the actual March 31st date, we have to run certain reports such as what is the accrued interest on all of our investments for our clients, because we include that number on our financial statements. There's some analysis that is done on particular items such as duplicate transactions, which is where you have an item that has to be referenced on, for example, if you have two estates, and they have to be referenced on two estates for court purposes, but for financial purposes, you only want one of them showing. So we go through and we remove those type items. So at probably, let's see, the auditors usually come in around April, and they do a count of our all of our investments to ensure that they are correct, that the numbers that are on our financial statements are accurate. And then they would come in and start testing some of the reports that I provide them, such as what are the revenues of the clients. So this is the information that is coming from the PAM system, basically the funds that are coming in for our clients, their pensions, annuity payments, as well as their expenses. So in that case, the payments for Nova Scotia Power, for their cost of care, for even like distributions of the estates. So we do provide a report where that falls on our income statement, and that is tested by the Auditor General when they come in and do their financial audit. Risk of error. The reports that come from the PAM system are put onto Excel sheets, okay? It's basically a copying and pasting process, of which then they total up, and then these numbers then go on to our financial statements. I'm trying to think what the risk would be there. Possibly data entry, maybe. But any of our numbers that are run through there, they are verified. So for example, if we have, I'm trying to think of an example here.
So the Oracle system is planned to stay in place then with the continual moving over, or you're actually eliminating that now?
Actually, thank you. What we have done so far in regards to that particular recommendation is we have gone through and we have identified all the elements that have come out of the recommendation from the Auditor General to ensure that they're going to be included in any program we're looking at. At this point, we're looking at having a business case completed, of which we're actually meeting with them this afternoon. A consultant has been hired, and we expect to have the results of the recommendation by June 30th. What we expect from them is all the recommendations that came from the report to ensure that they would be implemented, as well as providing a cost-benefit analysis of each option that they do come out with, and having a recommendation for the best program. The programs we assume that they will look at are the public trustee accounting system, other programs that are out there, such as ACPAC or Simply Accounting, or even like the government SAP program that's out there. When this recommendation comes out, we have to ensure that it is going to be a program that is supported by IT. It has to be expanded. Between 2006 and now, There have been so many changes with accounting standards, as well as how we present our financial statements. We need a program that's going to have the ability to be changed, to include more information, to give additional reports as they're requested. Also, it's very important that the program that we end up with will work operationally with our current accounting processes while not adding any additional accounting staff. You know, we don't want a double entry, for example.
Yeah, I would say that is one of the risks likely that would be, and you talked about the copy and paste, and
yes,
I guess there's always a risk when you're moving anything, but certainly that and the ease of use too. And I'm not technical in any way, shape, or form. I know a little something about basic things, but you know, I think about Access. You can enter tons and tons and write all the programs you want and create all the reports you want, but I'm not sure that that works. It seems rather a simple thing to do,
yeah,
and it shouldn't be that complicated. One quick question I would ask is, again, and I asked it toward the end of my last set, was compared to other jurisdictions, everybody's obviously in the same circumstance. They're all trying to account money in, money out. Again, it sounds rather simple. Is part of this, you know, you're meeting this afternoon and you're trying to put together things. Are you looking at those jurisdictions and say, hey, this works great in said province and it's been audited. We know that, you know, nothing's ever risk-free, so I don't want to use that term, but the risks are minimized, and is this the process we're looking at here?
The other public trustee office, I would assume, would be included there. But just to let you know, when we've already done our analysis, we completed it back for the public trustee accounting system, as well as we've had discussions with the other offices when different changes, standards were coming out, and we started talking about how things are accounted for on their systems. We did talk to them about what programs they were using. A couple names came up, of which I think some of them we had actually already checked when we had looked into the original public trustee accounting system. Some of the issues there were the sheer volume, for example, that may go through for transactions in, let's say, Ontario. And therefore, their program, if I remember correctly, like you're looking at a multi-million-dollar program, which we don't have that, right? And it's not really needed for the numbers that are going through our system. From talking to the other offices, what was interesting was some of the items that we've kind of addressed of that may come up when looking at a new accounting system, such as, let's say, gains and losses, trying to think about how they will be accounted for properly, because there's some analysis that's required. What was interesting when I talked to them, they actually said the same thing, like, you know, their program might be able to pull this information, but what's interesting is that a lot of the times they have to go through it and analyze and kind of adjust it all the way through.
Thank you. Just quickly, I know I'm running out of time. I've got about a minute and a half. The total transactions through your office last year were 47 million, 43 million? I know you quoted it, I'm sorry.
Ontario?
The total value of our assets under our care is 47 million.
Okay.
But I believe, and Ms. Whitaker could best tell us, we received income in of pension checks, interest checks, et cetera, of about 7 million.
Okay. And I'm just, I don't want to cut you off, but I'm down to 1 minute, and I apologize.
9 million. 9 million out.
Okay.
7 million of income in.
So to me,
these are transactions.
Right. So to me, that's a lot of money, and I would think to most anybody that's a lot of money. And of course, the accounting of the assets is a great deal of money. It's interesting when you talk about a multi-million-dollar system, and again, maybe I'm a little too simple on some of this stuff. I couldn't imagine we'd be looking at that kind of figure, but maybe we are. I would see 9 million even at that being significant, and that we would want a system, and if it cost us, I'm sure there's got to be a cutoff that's reasonable and program that works. So I guess I just want to, in closing, say that I think we're dealing with a significant amount of money and trust in this. So I would hope that in part of the recommendations being completed and counted for, that we are going to spend what's necessary to make sure that we're looking after the people's and the public trust. So I know my time is up, Mr. Chair. Thank you.
Thank you, Mr. Porter. Mr. Ramey.
Thank you very much, Mr. Chair, and you've already answered a good number of my questions, and I think Mr. Epstein, my colleague, still has a few, but I just have two really quick ones. And one is just to get clarification on something that Mr. Younger actually asked earlier on. This term came up which I was not even familiar with, and I guess that's why I'm asking the question again about this register where people's names go if they pass on.
Oh, the Royal Gazette's.
The Royal, yeah, and I think Mr. Younger asked the question like, kind of like, who knew? I mean, I've never really heard much about that. How does one find out about this other than Googling it or something like that? I mean, how would the ordinary citizen know this, since none of us seem to know very much about it?
The Royal Gazette has been how do you find out about it? Online, I would think, but it was and still is a paper edition.
Okay.
I would think they're available in public libraries. I can't confirm that. They're definitely available at the public legislative library, I'm sure. Any lawyer that's involved assisting families about estates would know of the Royal Gazette. Credit companies, debt collectors actually follow the Royal Gazette. Trust companies do. I know some of the charities do that because I've been told that by some of the charities to say, we knew that this lady had named us. There's a lot of information in the Royal Gazette, and I know I will fail in telling you everything that's there, everything from the appointment of when someone's appointed a commissioner, things dealing with motor vehicle matters, corporations. I'm looking at Mr. Epstein for help. Every deceased file, when it's first started, the notice for a deceased file appears for 6 months in the Royal Gazette.
Okay.
And it's a weekly publication. Motor carrier things. This publication has been in existence.
I've heard of the Royal Gazette. I just didn't know that it did the death thing there. But I guess my point would be that for many of my constituents, for instance, they don't have a computer, never had a computer, never plan to get one because they're seniors, and that doesn't mean seniors don't use computers, because lots of them do, but many of my seniors don't care to have one, and may not have a lawyer, may not have a will, may not have any of that, so they wouldn't really know what the dickens the Royal Gazette was. So I guess that was my point there. My second question, and then I'll turn it over to Mr. Epstein, is the Auditor General had a number of recommendations around employee access and inventory procedures in the storage vault. Can you just tell me what's been done about that at this point?
That can be best answered by Ms. Whitaker.
Okay, thank you. Go ahead,
Ms. Whitaker.
Thank you. We had already been completing on an annual basis an audit of all the items in our vault. Our vault is basically when an item comes in, gets inventoried, and is kept on site, is kept in this secure, alarmed area that is only accessible by accounting. The problem that came about during the performance audit was when asked, well, can you confirm and tell me when it was done and who completed it? Well, no, we didn't keep the documentation. So right away, we created a policy that states once a year, 2 people, one which will be an accounting person, the other preferably a non-accounting person, will go through. We actually run these particular reports from the public trustee accounting system, which references every item that should be in that vault, and we do a cross-reference, and it's signed off on by both parties, and it is kept on an annual, each year, it is kept in a particular file so that if we ever have to refer back to it, we can confirm exactly what was there and who reviewed it.
Okay, thank you. Thank you very much. I'll turn it over to Mr. Epstein again.
Mr. Epstein.
Thank you. As you recall, I was just running through the Auditor General's recommendations, and next one would have been 616. But I gather from your exchange with Mr. Porter earlier that the state of play on that is that you're very close to choosing a financial accounting and reporting system. Did I understand that correctly?
We will hope to have a recommendation by June 30th after our consultant reviews all the different programs that are out there and gives us the best options, again, on cost, what will be, best supported, as well as for what will meet all the recommendations that came from the report.
And when you have chosen a system, how quickly after that, Ms. Whitaker, do you think you'll be up and running with it?
I think it's really going to depend on what program is recommended, how quickly, with the help of IT, that the program can be, either if it's a new program totally or in addition onto our current system, how quickly it can be put on as well as tested to make sure that the information that is coming out of it is correct and accurate.
Is it a question of weeks, a couple of months, 6 months after that? What do you know?
It's really hard to say at this point because we don't really know what the product is, what the recommendation is going to be. If it's, let's say it is a modification to the public trustee accounting system, we would then go to our IT people because they also are aware that this is a very pressing and serious recommendation. Okay. And ask, how long would it take for such a modification? What is the best way to go about this? So our plan is, as soon as we get the recommendation, to keep moving on this very quickly.
Okay, thank you. I have another question about how the money assets that are in the hands of the public trustee are accounted for. And I see that you have something called a common fund, and there's also a special reserve fund. And I'm wondering if you could explain exactly how this works. My impression reading the books is that the common fund is where the assets are pooled. Yes. That is the assets of the clients or the beneficiaries, yes, that you're dealing with.
Yes.
Is that correct?
That's correct.
Okay, so so that would be the basic, most important fund that you operate. Is that
correct?
Right? And so, just what exactly is the special reserve fund? It wasn't 100% clear to me just how money actually got generated for that and what it was used for.
Sure. I'm going to start off on this, and I may defer to Estelle if it comes up with something a little bit through the legislation. The Special Reserve Fund is a fund which is maintained between the Public Trustee Office and the Deputy Minister of Finance. What is basically held in there are longer-term investments. The money, if I can kind of walk us through it there, is that any excess funds from our clients are invested in what is called common fund investments. These investments on an annual basis usually will create income. And then that income at the end of each fiscal year, after the audit is complete, will then be transferred over to the Special Reserve Fund. And the Special Reserve Fund is comprised of generally longer-term, very secure investments which earn interest.
I guess what seems to appear as I read the financial report is that some of the interest generated by investments would be allocated to the clients themselves, yes, but some of it seems to flow to the Office of the Public Trustee. And am I reading that correctly?
That's...
Ms. Theriault?
I think I wish to go back 3 steps to explain a bit more about the common fund. The common fund is where the initial checks are deposited. Someone's bank account money, $1,500, $2,000, and their pension checks. It has been our practice to buy individual investments for our clients' funds. In the client's name, Public Trustee and Trust for Mary, Public Trustee and Trust for whatever. What we tend to keep in the common fund is just the monthly or 2 months needs of that client. We have a policy and procedure established that excess funds in that account are not left there. We buy individual certificates or shares, whatever, depending upon the amount of money the party has, their age, etc., in the individual's name. So our common fund is largely like the client's bank account. So it's not all the, say, 35,000 or 35 million, let's say, cash. We have individual certificates in another reporting schedule. What we have in the common fund is basically the client's bank account, the small amount of money that we need to keep for the client.
I think I understand that. I think the point of my question really was what determines what portion of interest return
There's a regulation
is allocated to the individual and what portion is allocated to the public trustee's office for its general purposes.
The amount of interest that a client can earn in the common fund is set by regulation, and it is, I don't have the regulation off the top of my head, I apologize, but it's a very low amount. It's almost like a savings account, as you would not be expecting to earn large money on your checking account. Any interest that can be credited to the client is done so pursuant to the regulation. Any excess interest over and above that does not have to be paid by the regulation is the amount that is transferred to the Special Reserve Fund. The Special Reserve Fund was established to meet if the Public Trustee's office was ever dissolved, if there was ever a shortage in, say, what we had to pay. I don't know how the shortage would occur, but that would be our stopgap.
Okay, so the amount is set by regulation. It's only about $2.5 million in the Special Reserve Fund as I read it. Is that right? Yes. No?
A special.
Ms. Whitaker?
Well, I'm looking at page 13 of your last annual report. It seems to be about, $2.4, $2.5 million. 2.6, I guess, as of March 31st, 2012. I mean,
I'm sure you're right.
This is,
That is, without looking at it, that sounds very familiar, yes.
okay. Thank you. I'd like to move on to something else if I could. I'm curious about the position of infants that might be amongst your clients. And again, I'm looking at your annual report from last year. I see that you have listed amongst your almost 1,300 clients, 192 infants with estates, and these are infants who are living. So would some of these be, for example, minors who are orphaned but have no relatives that would step in?
Ms. Terrio?
The children we have under our care may be orphans and may have both their parents alive and well. A parent is guardian of a child's person by law. You may decide where your child goes to school, may surgery, or sign a consent to go to camp. In no jurisdiction in Canada or in England is a parent automatically guardian of the finances of their child. There is a piece of legislation called the Guardianship Act, which actually I drafted a number of years ago, which establishes a procedure that a parent may go to the court and be appointed guardian of the finances of their child. And our legislation, bonding may be required, it may be waived by the judge. So parents, if there are funds payable to a child and there's no trustee named on the beneficiary card, or they're receiving funds through intestacy, if there's no court-appointed guardian of the finances of that child, the Public Trustee of Nova Scotia is, without court order, guardian of the finances of every child in this province. Therefore, the funds we have in trust for those children come to us in various ways. A father may have died, they were divorced, the child's the only heir, the mother does not apply for guardianship under the Guardianship Act, the funds are paid to my office, I hold and invest the funds for those children, the funds are used for the maintenance, education, support of the child, we hand over when they're 19. It could be in a life insurance policy, a person at work names their child without trustee, so that's how I get the funds. And if I get the funds through insurance or intestacy or beneficiary of an RSP, and the parent then decides, I'd rather manage it, not the public trustee, and we always encourage them to do so, if they get appointed guardian of the finances of their child under the Guardianship Act, the public trustee immediately will account to the parent or whoever's been appointed guardian of the finances. So the children that we do have, they come under an assortment of ways, and it could also be as well. We are asked by the courts often to be a trustee for children for court-awarded settlements, and because the courts want a bond. Our courts are very protective as far as wanting to protect those that can't protect themselves, so we're in great favor of bonding in this jurisdiction, and I support it. So I have some funds as well that I've received by court order.
This is a very interesting point. Thank you. Do I have a couple more minutes?
About 8 seconds.
8 seconds. Well, in that case, I'm sorry, but thank you for your answers to all my questions. It's been a big help.
Thank you.
Thank you.
Thank you very much. I'd asked Ms. Theriault if she has any wrap-up comments.
I know I only have 2 minutes, and you know I can go on at length. I do want to thank the committee for inviting us. As I regard this as an opportunity to allow the MLAs that are passing laws, that are dealing with their constituents, to know what we do. We do excellent work. I'm very proud of what we do, and I thank you for taking the time to listen to us today, and I apologize if I went on at length and you may not have got all your answers, or to all your questions. Thank you.
Thank you very much, and it was very informative today, and indeed, thank you for coming. We appreciate your appearance here. Just some committee business now. The requested information of the meeting of March 27th was received from the Department of Finance, and that has been distributed to all members. There will be a subcommittee meeting immediately following this meeting today in camera to set agenda, and there will be no in-camera meeting on May 1st due to rescheduling of the witnesses, and the meeting of May 1st has been canceled because of some difficulties getting witnesses here. Our next meeting will be May 8th, and it'll be Department of Community Services Rehousing Development Corporation, and be no in-camera briefing at that meeting. And the Trade Center has been rescheduled to June the 12th, 13, and there will be an in-camera session on June 5th regarding that. Unless there's any other business, in order to stand adjourned. Thank you, Mr. McKinnon. We stand adjourned. We'll do about a 5-minute recess here so we can get everything set up for the in-camera meeting.